Continuing with our list of executive session purposes, deliberations concerning labor negotiations, and then to acquire an interest in real property. And I always like to point that out because folks like to go in for what they call the real estate exception, but it's only if you're acquiring the real estate, not necessarily if you're selling it. Records that are exempt from disclosure, we're going to go over the Public Records Act. Essentially, if you've got a record that falls under one of the exemptions in the Public Records Act, you can go into executive session.
Can you executive session to sell property?
No.
Okay.
Unless your counsel's giving you legal advice.
Yeah, unless there's some
prior.
other, if you do go into executive session, it's going to be under some other exception. And so it could be the exception under, that we just reviewed, D, consider records that are exempt from disclosure, or it could be one of the later exemptions with regard to litigation, for example, or risk management. But it's not going to be under C. It will be under some other exemption.
And it's not the fact that you are selling the property that you go into executive session. It has to meet the criteria of the other section. It's not the fact that you're selling the property that allows you to go in.
There's something else at play there. Preliminary negotiations in trade or commerce in which you're in competition with governing bodies in other states or nations. And so, for example, say Costco came here and said, we don't know if we should build in Pullman or Moscow, who can give us a better economic development deal? You could probably go into executive session to discuss that. And that's a good example of how that one works. F is to go in to communicate with legal counsel for pending or imminent litigation, meaning you've either already got a case filed or you have a case about to be filed. Again, when you think about it from a notice point, if it's a case that's already filed, you may want to just put on your agenda executive session to discuss Moscow versus Smith. Because now if the public can say, oh, that's the case they're going in to discuss, you haven't given anything away because everybody knows the case is filed, you're just discussing that. The other thing to keep in mind is that the mere presence of legal counsel at an executive session does not satisfy this requirement. And so folks sometimes think that if our attorney's there, we can go into executive session because it's all attorney-client privilege. Well, it doesn't necessarily work that way. In the public records law, we get the same argument from folks who like to copy their attorney on every email, and then they say, well, I copied my attorney, so it's a attorney-client privileged communication. It doesn't work that way. G and H are very specific, and then I is for risk management, public agency risk manager, and it's for claims that are pending or a claim imminently likely to be filed. And so, for example, say someone passed a snowplow on the right and got buried and driven off the road, and you know that that's coming, that's probably a justification to go into executive session. And note, the same limitation is there. Just because your risk manager is in the meeting doesn't mean that it qualifies under this provision. Again, the common thread through each one of these exceptions is a specific object, a specific purpose, something directly that you can point to that says this is why we're in executive session.
Yeah, but boy, we're a close-knit community, and we're kind of like a family. We fight like cats and dogs. And we don't want to hang out our laundry, our dirty laundry, for everybody to see, because we can come out and sing Kumbaya at the end, and everything's going to be fine.
That is an excellent policy point, Mr. Attorney General, and I would invite an introduction of a dirty laundry exception to be introduced with the legislation. But that would be a funny one to put in front of a committee, wouldn't it?
I'm not doing it.
No, me either.
Do you mean there's not a dirty laundry exception?
There is no dirty laundry exception. The exceptions are narrowly construed. And I think that, I like to think of these as exceptions, and I like to use the word exception, because when I look at the open meeting law, executive sessions should be the exception, meaning ordinarily all business is done in the open. except in those rare instances when we actually have to discuss one of these things. Which means that you've got a couple of things that happen there. Number one, if you try to do something in secret, everybody's interested. The minute you tell folks you can't come in, everybody wants to know what's going on. And one of the things that I've noticed is that the more folks talk about having an executive session, the more folks are interested in what's going on in the executive session. If you have an open meeting, nobody shows up. And you know, I hate to say it, because I actually love government and I love working in government, but it's really boring when you sit through some of these meetings. And I think that the public generally understands that. So anyway, if you're having attendance problems, you might want to try the secret route. You'll get butts in the chairs. The other thing that I will tell you, and the Attorney General alluded to this, is Idaho is a very, very small state. All of our communities are very, very small. I mean, I would imagine that everybody in this room pretty much knows one another already in some capacity or another. There's not really a lot of surprises based on the folks that are in this room, and I can kind of tell that based on the interaction beforehand and everything else. That comes to what Ben Franklin said about secrets. Ben Franklin said the only way you keep a secret among 3 people is if 2 of them are dead. And so when you're contemplating executive sessions and thinking, oh, we're keeping these grand, great secrets of government together, remember Ben Franklin. And then reconsider, think, do we really need to do this in executive session, or should we, you know, and that way you wind up only in executive session for the most worthy of needs, the most specific of purposes.
Well, Brian, you know, on my board, George, we had an executive session, and George just ran right out and he told the paper everything, and he blabbed his mouth, and I want to know, I want you, as the Attorney General, to impose a penalty on him for violating the executive session.
Yes.
I've never heard this before, by the way.
Well, that's actually a question, as you know, we get quite a bit. And the answer to it is there is no penalty. If somebody goes into an executive session and blabs it all over town, there's nothing prohibiting them for that. Now, if you're on a board and you're thinking about going into an executive session and blabbing it all around town, as an attorney, I would strongly advise you against doing that, because you may be exposing your board to significant liability. You may be putting your board or your entity in a position where they're legally vulnerable. A great example is in settlement negotiations. If you go out and you say, we just approved a range between $80,000 and $120,000 for settlement, guess where that settlement starts out at? $120,000. And so those are the things to think about when you get into that scenario.
Oh, you just don't want to help me, that's all.
I would love to help you. The other thing is there's a little pesky thing called the First Amendment that gets in the way of really penalizing somebody that comes out of a session and says things like that.
And as a reporter, I'm actually really glad when they do.
You can't make a final decision or take final action within an executive session. And then this is the section, we kind of went over this before, but you do have to take minutes of the executive session. It has to specify the specific statutory reference, but you don't give away the purpose of the executive session.
Well, Brian, if you don't take any final action, you can't get out of executive session then, because you got to have a motion to get out of executive session. Or just evaporate into the atmosphere.
So you bring up a good point, and I like to think of it as the open meeting chicken and egg problem. Because if you take the open meeting to its logical extreme, you would never be able to come to an agreement on when to hold the meeting. And so there is actually an element of pragmatism that's associated with it. So for example, to adjourn out of the executive session, obviously you need to adjourn out of it and deal with that. The key is you can't take final action on the actual topics, the substantive topics. The motion to adjourn is simply a ministerial function of the board that doesn't rise to the level of the open meeting law. You're getting tricky tonight, by the way. And good news, you guys have made it to enforcement. Yes.
talked about getting into executive session, how, why, and when. What about beyond that motion to adjourn? If a mayor and city attorney see a reason for an executive session, a legal good reason, it goes on the agenda, it's noticed at the end of all the action items on that night's agenda. Do they have to come back out of it and come into public session to adjourn for the evening? Or can
Yeah.
they, or, I think I've already got the answer, but, or can they announce we're going into executive session 4 and we will not reconvene?
No,
Because they don't plan to make any
Right.
decision.
My recommendation would be that you go into executive session and then you come back out and adjourn properly. You don't just adjourn into executive session, because again, you kind of lose the benchmarks. And to me, good parliamentary procedure is you go into executive session, you come back out of executive session, and then you adjourn your meeting. You don't adjourn your meeting and then convene an executive session only meeting, which is what you're essentially
Is it,
indicating.
would it be okay to advise the public, we're going into executive session, we do not plan to make any decisions after the
Yes.
meeting?
Yep.
And plan to adjourn immediately after, so we don't make people sit here for 45 minutes to an hour to come out and watch us go home.
Yep, that, and that actually is, I mean, to me, that's not an open meeting question, that's a good customer service question. The real key is to make sure you stick to that, meaning you don't go into executive session and then have the, Lee Corso, not so fast, one more thing, moment when you come back into open session. You look out over the crowd and you say, well, nobody's here, let's cite that Walmart. Those are the things you want to be really wary of.
Thank you.
And when you dissolve out of executive session and then you come back into public session, and typically what we do is say, and we took no action in executive session, the motion to adjourn that meeting is a public session motion. It's in the regular, normal course of business, not part of what you can do in executive session. So that motion is made publicly to adjourn.
It also helps, for example, for keeping track of how long you were in executive session for minute purposes. We spent, at 6:03, we adjourned, we convened in executive session. At 6:14, we adjourned out of executive session and back into open session. So then folks can kind of track the meeting length and those sorts of things as well.
And from the public's perspective, even if you've already announced you're not going to take any action, when you do go back formally into public session, I think it's advisable to open the doors. Because as a reporter who sometimes feels the need to wait outside, just in case, to check if they took any action or not, that's my clue.
Should you knock before you hit them in the ear with a door?
That's right. Move the glass.
Can you meet solely for the purpose of meeting in executive session?
Yes, and we went over that. You can have an executive session only
Okay.
meeting.
I
You have
apologize.
to have a notice, that has to be noticed up in an agenda with 48 hours. And on that agenda, you have to state the specific purpose of that executive
But
session
Do
only
you
meeting.
still open that as a public meeting?
Yep,
and
start
then-
out open.
Okay.
Exactly.
Very good.
Think of that for a moment. In order for you to go into executive session, you have to have a 2/3 vote. That vote has to be taken in public. So you have to commence in public session, dissolve into executive session, dissolve out of executive session, move to adjourn in public session.
Okay, very good, thank you.
You guys are also getting a nice primer on Robert's rules along with this open meeting presentation tonight.
Full service,
Full
full service.
So now we're at enforcement, and any failure to comply with the provisions renders the action null and void. It's important to understand that something has to happen to make it null and void, meaning you don't just show up and say you violated the open meeting law, whatever decision you made is null and void. Either the board has to say, yes, we messed up, those actions are null, or you go to court and the court says, yep, they violated the open meeting law, those actions are null and void. So some other thing has to happen to make them null and void.
Now, what if you're, say, a county commission and you just don't think you really screwed up?
We're going to get to that in a second. If you participate in a meeting, that violates these provisions, you are personally liable for a civil penalty. First offense is $50, a knowing offense can be up to $500, and a second or repeat offense can be up to $500 as well. Important note with the penalties, those are to you as a person, meaning your government doesn't pick up the tab for you violating the open meeting law. Those run directly to you. The other thing that, I mean, folks, one of the common criticisms that we get is that folks say that those penalties don't seem too steep. But remember, most of those penalties also carry with them a fairly heavy public price. And so that's one of those, I mean, when you're thinking about it from a deterrent effect, a $50 fine that's trumpeted on the front page and the editorial page of the paper for a good long time, that's pretty punitive. And so it's always important to remember to cast them against that backdrop.
And let me throw in here, you know, I participate in public meetings, and that there's a $50 fine, a $500 fine. Is that enough? It's not enough? It needs to be more, it needs to be less, whatever. As a public official, the very fact that I hold this public trust, and it's determined by a court that I have violated that trust, it doesn't matter whether it's $50, $500, or $500,000. That's a terrible penalty to me, the fact that I violated that trust. I'm not sure that everybody fits in that category, but you need to know that's how I feel about it.
So when it comes to enforcement, the Attorney General enforces with regard to the state government. For all of the local units of government, including the county, it's the county prosecutor. And then the third category is any person affected by a decision of the government can bring a cause of action for a violation of the open meeting law. And so there's 3 levels of enforcement. Most importantly, any citizen can bring an action if their board violates the open meeting law.
Yeah, but Brian, you know, the library district, and they violated the open meeting law, and I reported it to the county prosecutor. He wouldn't do anything about it, and I sent you an email, and I kept you on the copy, and I told you this was the problem, and you've got to do something about it.
Well, under the law, we cannot do anything about it, Mr. Attorney General. You can introduce that to the legislature.
You just don't want to help me.
No, that's not the case. And to me, that's what we get that question a lot. You know, we want you to look at the open meeting law, and our answer is always, you have to start with the county prosecutor. The other thing that we tell folks is you can bring an action yourself. And a lot of folks find both of those answers to be really unsatisfying, but that's what the law says. And so to that end, understand that that's where the lines are drawn within the law. I will tell you that at times when a county, for example, has a violation of the open meeting law, a lot of times the prosecutor will ask us to take a look at it because they understand, look, this might be a little too close to home for us. And we do get involved in those circumstances, but it requires that the county prosecutor ask for our assistance.